Welcome back to Canadian Justice, where we're discussing employment law issues. Now, Andrew, in the last segment, we were talking about this case involving time theft, where it seems like an employee was let go with cause. She sued for wrongful termination, and then the employer countersued for time theft. And it seems like the employer came out ahead in this case. Can you explain what happened in that case?
I think you've done a good job of explaining the basic facts. She was terminated for cause for time theft and claimed wrongful dismissal damages, but the employer counterclaimed for wages that it paid to her for the period that she claimed that she was working but was not. The tribunal ultimately dismissed the employee's claim and ordered her to pay the employer approximately $2,600 in debt and damages for the time theft.
Now, Mackenzie, how common is a claim for time theft like this, and how difficult is it generally to prove? I mean, basically, what should employees and employers know with a decision like this? What should they be aware of?
So this is an example where the employer was very organized and really did cross their T's and dot their I's when they were creating this just cause dismissal. So the important thing to note is that they had specific time tracking software that was able to track when this employee was working on certain files, what work was done and for how long. And in addition to that, they also did a pretty thorough investigation into the discrepancies between what the employee's time entries were and what work she had actually completed. And they also thoroughly, they obtained an admission from the employee. So this is one of those rare cases where the employer really has done their due diligence and done everything necessary to really support their just cause dismissal. So it's not common. It's a very difficult threshold for an employer to meet. But certainly when an employee is claiming that they're doing work and getting paid hours of work for work they're not completing, an employer does really need to take action and make sure that they're really thoroughly investigating and properly tracking and documenting what's going on.
Andrew, is there anything you want to add to that about the standard, how difficult it is to prove, or maybe even this issue of time monitoring software on an employee's computer? What should people be aware of about that?
Yeah, I mean, I think Mackenzie's comment there about it being rare is exactly right, because of the difficulty in actually being able to cogently prove that the time theft occurred. So in terms of how to potentially track that, I think that employers really should consider utilizing software for employees who are working remotely, if they believe there's a time theft issue or even if they're not. So, in terms of limitations regarding tracking that sort of productivity, generally employers are allowed to utilize software to track an employee's productivity as long as the software is not tracking and storing their personal information. I would note, as many folks know at this point, that under the recent amendments in the Employment Standards Act, there is an obligation for companies with 25 or more employees to have a written electronic monitoring policy that describes how and in what circumstances the employer may monitor employees. So that's important to have that policy, but it doesn't mean that you can't track. It doesn't mean that you can't implement that software as long as you're not collecting personal information.
Mackenzie, we've got about a minute and a half left in this segment. What other types of cases are we seeing arising out of work from home employment?
I'm actually coming across a lot of issues with jurisdiction. So what I mean by that is, for example, when an employee is hired to work for a company out of, for example, their New York City office, but throughout the pandemic, they've relocated and moved to Toronto, and now they work full-time from Toronto, their employment is actually governed by Ontario employment law. It's no longer governed by the New York law that they were originally hired under. So when that New York City company now goes to terminate that employee, they're now subject to Ontario employment law, and they're likely owed significantly more in severance than what the American company originally thought. And so I'm coming across a lot of instances where companies have not really tracked where their employees have moved around throughout the pandemic.
Yeah, I'm interested if that is governed by the employment contract, because you stipulate in the employment contract that you can't move out of a certain jurisdiction.